Welcome everyone for the National Webinar Program. This is time to give welcome to speech. I call upon Mrs. Kalayarasi ma'am to give welcome speech. Good morning everyone. I am presenting the welcome address. Firstly, I am pleased to welcome the management personnel, Chairman, Vice Chairman Mrs. Sumanata Bhaskar ma'am, Secretary Mr. K.V. Kishan Kumar sir, and Director of Institute of Management Mrs. Shri Kishan Kumar ma'am. I wholeheartedly welcome our Principal Dr. V. Vijayalakshmi ma'am, Vice Principal Mrs. N. Maitri ma'am, and our department heads and faculty of this wonderful section. My special and warm welcome to the Chief Guest of Dr. M. BETKAR Principal, Shri Kumarswami Mahavidyalaya, Ausa. Welcome you, sir. And my heartily welcome to the beloved students who are attending the webinar. I call our HOD ma'am to introduce our chief guest. Dr. M. BETKAR sir, Principals of Shri Kumarswami Mahavidyalaya, Ausa. He is research supervisor with 30 years teaching experience. On his name, 7 patents are registered. He invited as chief guest by international conference as keynote author at Singapore, Hong Kong, Canada, and UK. He has presented research papers in international conference in Indonesia and Thailand. Sir published 50 research papers and he awarded for research innovation in Inter-University Research Festival, Aviskar. Sir received gold medal. He worked as Best Principal 2021 and awarded by SRTM University, Nanded. He awarded as Best Teacher of the Year 2018. He also invited as speaker from all over country for more than 250 speeches as intellectual property rights and as also NAC subject. In International Books of Records and India Books of Records and Asia Book of Records 2022 recorded his name as researcher. Thank you, sir. This is time to get knowledge about intellectual property rights. I request our chief guest to share his words.
Thank you to all the organizing committee members. I am audible.
Yes, sir. Yes, sir.
Thank you. This is the Accord Sai Shri Mahalakshmi College, Women College from Tamil Nadu. I am Dr. BETKAR MM. Good morning to all. Invited by the college to speak on topic IPR and patent filing. First of all, I would like to thank the Honorable Chairman of the Institute, Shri Thiru K. Bhaskaran Sir, Honorable Vice Chairman Ma'am, Tirumati Madam, Honorable Secretary Sir, Thiru K.B. Kishan Kumar Sir, Honorable Vice Secretary, Tirumati Shiba Kishan Kumar, Director of ASIM, and the Chief Organizer, Principal Madam Dr. Vijay Lakshmi, Vice Principal Maithili Madam, the organizer P. Anita Madam, and HOD of PG and Research Department of Commerce, all the faculties of this institute and students. I welcome all of you, and I would like to share my PPT, which is based on the intellectual property rights and patent filing. As we see that when we academicians, I request to organizer to allow me to share the screen, please. Yes, thank you.
Yes, sir.
Yes, okay. So we all the researchers, academicians try to publish our research paper, try to do some innovative things in our academics area, but we can't file the potential of creating intellectual property from that. Publication of the research paper, creating some innovative models, innovative things for us is a different thing, it's the regular thing. But if you find some potential in that to create the intellectual property, that is the more beneficial for institute, for academicians, and for the concur. Let us see the objective of my presentation. So today we are going to talk on intellectual property rights and the rights associated with the intellectual properties, and next process is to file a patent. How to file a patent? This is the objective of my presentation. All the students and faculty members, I hope, get benefited from that, because patent is not so much discussed, intellectual property is not so much discussed in our curriculum or in our regular activity, but it is very related to us, not from the academicians, but every citizen can file a patent to do some work, innovative work in his or her field. So this is the objective. Now in the next 1 hour nearly, we will see what is the IP, intellectual properties, what are the intellectual properties rights, what are the types of intellectual properties, what are the intellectual property benefits, what are the benefits from intellectual property, what is a patent, what is a patent filing, few examples and news related to patent, and some useful websites which are used to filing a patent. This is the scan of my PPT. Now let us see one by one. On the screen you are seeing that a person is thinking. It's the funny picture, but it shows that someone is thinking. The letter is side by side is I. What is I? In the word intellectual property rights IPR, we use the first letter I. What is I? I is the intellectual thinking of a mind. Since it's a natural thing that everyone thinks intellectually, that is the intellectual thinking can create a property. For an example, the person on the screen is thinking to create an intellectual property, that is the electric bulb. It's the example. Electrical bulb he want to create, or he want to produce that intellectual property, means intellectually thinking. Now the person is created a bulb. Now it is the intellectual property, means it is the property came from intellectual thinking of a mind. It is the intellectual property. Now what happens when we create an intellectual property? Then few persons from the society try to stolen your knowledge, try to use your technology without your consent or without your permission. So at that time, what we have to do? We have to prove the ownership of us with that innovation. That is, we have to register that intellectual property on our mind, on our name. That is these things happen on the screen, which are before the registration of the intellectual property. Now what happens if we register our intellectual property on our name through a proper process? That is the registration of intellectual property. At that time, we can exclude others to using that technology without your permission, without your consent. So that when we create an intellectual property, when we register intellectual property properly on our name, then and then only we get the ownership and we can enjoy the rights associated with that. So the rights given over the creations of a mind when registered in a particular office, that is the intellectual property rights. These rights associated with our innovation after registration, that are known as the intellectual property rights. Let us see what are the groups of intellectual property. There are two groups. One is intangible property and second is the tangible property. Intangible property means the thinking of a mind, the theme of a book, which is imaginary one, a song. These are the intangible properties. And in tangible properties, we use the solid material, means that is the bike, building, any farm, anything which is solid one, that is the tangible property. So from intangible property, intellectually thinking, by taking advantage of intangible property, we can create a tangible property. So these are the two groups, intangible property and tangible property. Let us see types of the IPRs, intellectual properties. What are the intellectual properties? Which are the properties known as the intellectual properties? Let us see. First, it is the trademark. Trademark is a well-known word to us. On screen, you are seeing that there are few collected trademarks by me. That is the Lokmat, Airtel, BMW, Parle-G, Doordarshan, and the WhatsApp. These are the trademarks which are used by that concerned organization to market their goods or to launch their software or to launch their app in the market. So before launching a software, before launching a startup or any entrepreneurship or any factory, we have to create our own symbol. As per our creation, there is no ban how to create it. Everyone is having freedom for that. And after creating a particular logo, monogram, like symbol, like on the screen, we have to register it in the trademark office. And when we commercialize our goods or marketize our goods, then we can use this symbol along with the packing of that. So that is the trademark. And trademark is related to the first intellectual property because it came from intellectual mind and it can give financial benefit and other benefits. So it is the first intellectual property. Now second intellectual property is the geographical indication. On screen you are seeing that Kanchipuram silk sari, Guntur chilli, Basmati rice, Kolhapuri chappal, Puneri pagdi, all these are the geographical indications of our India registered under the intellectual property. Few words we are knowing, all of us are knowing that Nagpur orange, Basmati rice, Paithani of Paithan, Kullu shal, Nasik Valley wine, Tirupati laddu. These are the geographical indications of our India. And Karnataka is ahead in registering the geographical indications. Since what are these? These are the famous products which are related to identity of that local area, geographical area, and they can be registered as a geographical indications proud of that area, and they are commercialized by using their identity. And when we publish this, register these geographical indications for our that area, that product goes to the market, to the world map, and local economy increases. And one most important benefit is that no one can claim that particular geographical tag is from our side. Since you are from Tamil Nadu and Tirupati laddu is from your area, so no one from Maharashtra or no one from rest of the world can claim that Tirupati laddu is our product. It's wrong one, because it is already famous, it is already registered by that particular state for by that area. So it is the property, intellectual property of that area, that state. So Kolhapuri chappal, like the man-made product, Puneri pagdi, man-made product, Kanchipuram silk sari, these are all man-made products. Means we can register intellectual property, that is geographical indications, from man-made or from the natural products. Now let us see the third intellectual property. It is the design or utility model. There is no so much scientific operations from that, but just the external 2D 3D nature of any design or any structure of a atom can be registered as an intellectual property, that is as a design or utility model. On the screen you are seeing that first is the example of the water bottles, which are very different. Every bottle is different, every design is different. So every design can be registered as a design or utility model. Second is the chair. You are seeing that we are all using various type of chairs. So someone can design a new chair as per the comfort, as per the durability, as per the use, as per the opinion of the customers. So that can be registered as a unique design. And third is the example of the goldsmith. Means when we go to purchase an ornament in the market, if it is registered under IPR, it can cost so high because it is registered, it is unique one, and we wish to purchase that unique ornament by paying the money as per the demand of that creator. So these are the benefits of the registering unique design under the design utility model. Fourth is the plants builder right. So it is associated with the plants, various seeds. As you are knowing that there are so much seeds produced by biotechnology, tissue culture, and cutting type plants. These are variety of plants. You are seeing that there are so much type of flowers on the same plant. This is the technique using cutting, tissue culture, biotechnology technique. So many plants gives best yield because of that research in the seed. So all these rights associated with the factors which are related to plant variety, breed of any tissue culture using seed, all these things. So this is the gives the plants builder right. And if anyone some innovated some breeds, some seeds which can give more yield, that can be registered and the plants builder right. Now let us see the fifth intellectual property, that is the copyright. What is the copyright? Copyright is associated with the media, that is like software, video CD, a book, audio CD, any painting. So all these media is related to copyright. Means if you see some book, at that book there is symbol C as like on the screen, which shows that who is the owner of this content, that is the copyright. If you produce some video or any drama or any if you broadcast some anything as per your creation, then that creation, when it is published, it is given a copyright to you. So book, software, all these things can be copywritten. The rights associated with this media is comes under the copyright. Sixth intellectual property is the semiconductor IC design. Semiconductor IC design is not a new word for to us. We use electronic component, mobile, TV, computer. So all these are working on integrated chips. The chips are functioning uniquely. They are used for that particular purpose because they have unique design. So these integrated chips can be registered as a intellectual property. Now, let us see the seventh intellectual property. It is the patent. It is the most important intellectual property because there is more scope for the innovation, more scope for the commercialization, and more scope for the demand from the market. So let us define the patent. What is patent? It is a monopoly right. It is particularly a right, monopoly right, given by the government, granted to a person. It is the right only. To whom we can give the intellectual property rights as like patent? Who has invented a new, novel and useful article. If someone innovatively created a product, a new product, novel product, useful product, if it is innovative, it can be registered under the patent. What is the second condition of that? It may be improvement of an existing article. I mean, there is no need to invent everything new article. But if you modify the existing article innovatively in some part, means in existing article, that innovative part can be registered as an intellectual property as like patent claims. Or third may be the process, new process of making an article. Let us define this. What is the new process? Suppose you are working in the pharmaceutical area. You are producing a medicine. For an example, paracetamol. Paracetamol is a name given by someone. Then doesn't mean that you can't file the patent on paracetamol in next time. But if we give a new innovative process for making the paracetamol tablet, then you can file the new process as a patent for that same product. So I think the definition is cleared. It is the monopoly right granted to a person, granted by the government, because he or she has invented a new, novel or useful article, or she may be improved a new existing article, or there may be process of making of the article new innovative process. And the basic thing is that article should be capable of industrial application. Means if there is no product from that innovativeness, it is only packed in the book, then there is no use. So that product should be capable of industrial application. This is one of the criteria. Let us see the types of patent categories. We are discussing here about the patent. Which types of patent categories? There are two types. One is the utility patent, which is most grandly or discussed, which is having innovativeness. There is process, there is some innovative linking between the instruments and the functioning working. That is utility patent. And second is a simple patent. It's a design patent. On screen you are seeing that there are two pictures. One is the picture of that goggle, and second is the picture of shoes. So here there is no any functioning, working or innovative, not any equipments are unrelated to each other, but the design, external design of that particular product can give a design patent. It is a non-optional, purely designs. Shoes, all these things, goggle or any chair or any bottle, any cap, all these things are externally, if you design that product, that is the design patent. Now, third is the plant patent. There are three types of patent. One is utility, one is design patent, third is plant patent. What is the plant patent? If a sexually produced plant seeds, if these are innovatively created to give a new seed, different plant species, to create a new plant, that is the third is the plant patent. If we use a sexually produced plant seed and sexually produced plant seeds. If you are creating a new plant variety, then that gives a third patent, that is the plant patent. These are the three categories. Now let us see what are the patentable inventions. Means every innovative invention is not patentable. So we have to consider a list. We have to take care of the patentable inventions. Let us see the machines, apparatus or other articles which are innovatively produced that can be applied for the patent. This is the first thing. Second thing, the process or synthesis, method of synthesis of any drug or medicine or anything that can be filed for the patent. It should be innovative one, synthesis process. Thirdly, the software used with the hardware to run the hardware, that is the third. Means if we are using just only software as like app in the mobile, it cannot be patented. It is just a copywritten. But if you use that software to run that hardware, any hardware, that can be registered hardware, that can be patented along with that software. Now, the food recipes, chemicals, medicines or drug are patented. Food recipes can be patented if it is innovative one. Chemicals means medicines and drugs which are created by using various chemicals, that can be patented, because when we wish to form a medicine, create a medicine, then we have to use different chemicals with different content, and when they mix together, they react in between. At that time, every ingredient loses its property, gives a new innovative product. That is the medicine or drug can be patented. Now, after the list of the patented inventions, let us see the non-patentable invention. It's must to know that there are so many inventions which are non-patentable. Let us see the first. Known inventions means if someone is knowing some idea, someone is knowing some product, that known inventions cannot be patented. Secondly, the inventions contrary to natural laws. If we have produced some product, innovative product, which is avoiding or contrary to natural laws, our natural laws, that cannot be patented. We have to avoid it. Thirdly, the innovations which are against public ethics and morality. We have to form our ethics of innovation. We have to stick with our morality. Then, which are against to this public ethics and morality, they cannot be patented. And number fourth, the equipments, innovative equipments, but causing basic of that objective for the commercial exploitation. If someone created some machine which is innovative, no doubt about it, but which is having the basic to exploit commercially, it cannot be patented, because we have to take care of society and all these things also. Now, the things which are innovative things which are harmful to our human health, harmful to animal health, plant life or to the environment, that cannot be patented, because we are human beings, we are taking of our environment. And in the other side, if you are promoting the innovations which are harmful to our health, our human life, animal life, plant life, environmental, that cannot be patented, because it ultimately creates danger for us, danger for our earth. So that cannot be patented. Now, discovery of scientific principles cannot be patented, because they cannot be equipped and we have no any contribution in that field. There should be our contribution, innovation. So discovery of scientific principles cannot be patented. Now, seventh, substance obtained by just admixtures. What are the admixtures? Admixtures mean the substances which are just together, not reacted in between. They gives different flavor, no doubt about it, but they are only mixed, not reacted. At that time, there is no any innovation, there is no chemical reaction in between that ingredient. So that admixtures cannot be patented. As like our lemon sherbet, lemon juice, if we create, we daily create at our home, that are the contents are not reacted, but they are mixed together. So such type of mixing of different chemicals or any solids admixtures cannot be patented. Now, number 8, the plant animals in whole or any part we can't patent on that because it's a natural. They born naturally, they are growing naturally. There is no our contribution as a innovation in that part, so we cannot file the patent on plant animals or windows or any part. Now number 9, method of medical cure, where there is no any equipments are used, just like massage, just like nadi pariksha, just like a physiotherapy, which is just giving relief to that patient. So these methods of medical cure without any equipment cannot be patented. On the other side, if you are using the equipment, medical equipment, so that if they are innovative, that can be patented. Now, method of agriculture or horticulture cultivation. These methods are free for using, they are utilized for the society. So these cannot be patented. These are without equipment, which are cultivating methods, which are available in the society, that cannot be patented. Now, 11th is the traditional knowledge. Traditional knowledge cannot be patented because it comes from our early generation reaches up to us, and we are also giving the same knowledge to our next generation. So this is a well-known things to generation, and that cannot be patented. One story on this is that when America filed a patent on turmeric, then India, means Honorable Mashelkar sir did a case in the court case, international court case, that turmeric we are using from ancient years from the India. Then these use which they have patented of the turmeric, we are using from so many years, thousands, hundreds of years. So we are having the rights of that patents of turmeric. So traditional knowledge cannot be patented, and we own the case. India own the case of the turmeric. Now, the atomic energy inventions cannot be patented for a normal person. If you want to file a patent of atomic energy, then we have to take permission from that Atomic Division of India, Government of India. So this was the list of the patents, innovations, which are patentable and which are not patentable. Now let us see a few funny examples of the patent. First, it is the anti-itching face mask. It is the funny example, but it is patented. Since if some doctor is given a suggestion to a patient not to eat in between, at that time this innovative mask is used to avoid the patient to eat without the permission of doctor or without in odd times. So that is the anti-itching face mask. This is the patent on back scratching. This is a funny patent, but it is filed. It is useful patent. So this is the funny patent, means patent comes from the need also, use also. At that time we file or we think to create some innovative things. Now this is also a patent filed by the officer to enhance the efficiency of the office, those who are not doing the work in time or in regular time. So this is the funny patent, but it is also filed. Now, the patent on seat belt, means you are seeing that there are so many patents on every parts on a bike or on a car. But if you design a new seat belt existing to the today's system, then it can improve the design such that it can be used for the society. Now, let us see 1 2 ka 4. This is the song in Hindi, but how we use this? One intellectual property is related to other intellectual property. This is the example. On the screen you are seeing that there is FM, digital FM tuner made by a company Philips. Let us see how this invention is related to other intellectual properties. The theme of that is registered under the patent. The external features of that FM digital tuner, its thickness, its switching arrangement, all this external color, all these things, they are design registered under design. The name Philips is registered under trademark, and the music you are listening or video you are seeing from that, that is registered under the copyright. So one invention is related to other intellectual properties. Let us see, if you not give a name Philips to that article, then someone find his name and stick on that and get marketed, and people will understand that this product is from that particular brand. So we have to take care of filing patent. If you want to produce some equipment, then we have to take care of registering patent of that, its external design of that, the trademark of our, and the copyright of that music, so that we take the benefits of that intellectual property in all dimensions, not a single particular way. Now, after seeing all these things about the patents, which patents are filed, which cannot be filed patent, which things cannot be filed, let us go toward the filing of the patent. This is the next part of our webinar or of our speech. What is the next part? Write down the idea as much detail as possible if you want to file a patent. Let us see the meaning of that. If you want to file a patent on a pen, then we have to think about its height, its clipping arrangement, its grips, also its nib or the gel which is used in that. So to file a patent on a particular thing, we have to write the idea as much detail as possible. Secondly, we have to check the patentability of subject matter. If you are filing a patent on a particular thing, if it is not patentable, as we have seen earlier, which is not patentable, then all exertion goes into waste. So that we have to, secondly, we have to check the patentability of subject matter. And if you confirm that it is patentable, it can commercialized, ventures can be attracted to that, we can file it for the patent. If it is confirmed, then you can go for filing the patent. Now, which forms are required and what is the fee of filing patent? This might be question in your mind. Let us see. There are only 6 forms. 5 forms are required for filing a patent. One is the form number 1, application for the patent. Second is the complete specific form. Third is the statement and undertaking. 9th is the request for publication, and form number 18 is the request for the examination. These are the forms named by the patent office, not by me. Let us see the description of one by one. Application for the patent with fees of 1,600, we have to submit it. And if we have a complete patent with us, then we have to file the complete specification form. Form number 3 is the statement I'm undertaking, that this is the just a statement with no fees, that this invention related to me, all these things. And form number 9 is the request for publication. Let us see the description of this. What is form number 9? We have to file it for request for the publication. Means if you not requested the patent office by paying the fees of 2,500 by filing the request for publication, then patent office give the queue to the form, and it requires 2-3 years or more than 1 year for publishing your patent in the patent journal. At that time, we have to request by paying the fees of 2,500, then patent office gives priority to that, and it can be published within 1 and 2 months. This is the form number 9. It's optional one. Form number 1 compulsory, form number 2 compulsory, form number 3 compulsory, form number 9 is the optional one, and form number 18 is also compulsory. If you not filed to the patent office for request of the examination with a fees of 2,500, no patent office examines your file application, and there is no issue of granting the patent. So these are the forms and required fees. Now let us go towards the various steps for filing the patent. First step is searching. I will explain in detail. Second step is drafting, and third step is sending. Let us see the broad meaning. Searching means we have to search the patent, related patent. Drafting means we have to draft the patent in the particular technical language. After drafting, we have to send or submit the patent to the patent office. These are the three steps. Now let us see one by one. First step is searching. When we publish our paper or any book, or we write anything, we always collect the related literature from library or for internet or any available resources, secondary or primary resources. That is the searching. We have to search which is the related knowledge about that, which is related literature available on that. That is the first step of searching. Similarly, in the patent also, if you want to file a patent, we have to search the related patent which are available on the websites. Which websites there are? There are 5 websites. Those are free websites. I have collected here, compiled for you, which are free one. That is the Google patent. Generally, we search on the Google patent everything, text matter, images, all these things. But you go for the search engine like Google patent, you get thousands of patent, lakhs of patent of Google patent. Second is the USPTO patent search engine. Third is the INPAS, Indian Patent Advanced Search System. Fourth is the ESPC net, it is the European Patent System. And fifth is the WIPO, World Intellectual Property Organization. So these are the 5th search engines. Lakhs of patents are available on that. We have to search your related patent on that, so that we can go ahead by searching the most related patent with us, and which we are providing a few modification in that. So before that, we have to search our patent in the search engine. For an example, let us see. I have searched 1 or 2 years ago on US patent search system, which is already given an example of that search engine in above side. That is, I just written a word PEN. At that time, I get more than 2 lakhs of patents on the pen. Since it is very strange thing that a single pen which we are daily using, it is holding a patent more than 2 lakhs. So that we have to search, and we doesn't refer 2 lakh patents for filing our patent, but which are most related to us. What is the improvement of your side, innovative improvement from that, you have to quote special that and refer special for that. Now second step is drafting. After searching, we have to draft the patent in the patent structure. When we draft our research paper, it is the title, then author's name, then we write abstract, then we give introduction, then research methodology, then calculations, then conclusions, and then acknowledgement. This is the structure of our research paper. But the structure of the patent is similar to that, and we have to write in the technological language. What is the structure of the patent of format? Then let us see. First, title of invention, we have to give particular. Then we have to give field of invention, in which field we are filing to patent. We have to give background of invention, means which is just regard to drawbacks of the associated, which are known to everyone on the available in the available literature. Second, what is your objective of invention? Then fifth number, statement of your invention. What is the statement? And then lastly, you have to give summary of your invention. And then you have to attach the brief description, drawing, all these things, detailed description, drawing, reference, and claims. Claim is the important thing. What is the claim in patent area? If you form innovatively applied for the patent on a pen, and you have to claim your innovative part on which you are going to filing a patent, these are the claims. If you don't give any marking or any claim on an innovative part which you have innovatively designed, then someone can claim the patent on that particular part and your exertion goes into waste. So what are the claims? Claims are the ownership, or your claims are the patentable articles on which you are going to file patent, on which you are going to register your mastery or your ownership. And then last, abstract just a simple one page extract of that patent format. Now after seeing the structure of the patent, let us see the sending process. This is third process. Sending process or submission process of the patent, there are two types. One is manual or second is e-type. There is no need to explain more on this slide, because manual sending means we just download the form, file the patent, type the patent, all these things, and we have to send the patent office through courier or by speed post or ordinary post. That is the manual sending. And second is e-sending. E-sending means without going away from home, we can file the patent from home with the website ipindiaonline.government.in, gov.in, e-patent filing. So this is the website which can be used for filing the patent through our home. So there is no need to do more exertion. Just download the form, print out, just compile your all form, text matter, and upload it on this website. Then there might be a question in your mind that where to submit the application. There are 4 offices throughout the India: Mumbai, Chennai, New Delhi, and Kolkata. But out of which our area is falling in which judicial area? Maybe from Kolkata, maybe from New Delhi, Chennai, Mumbai. So if you are from South India, you can file the patent from the Kolkata office. Means just it's a judicial process, just a collecting process. There is no any difference for filing between Mumbai, Chennai, New Delhi, and Kolkata, because all patents collected for the patent office are processed under one roof in one office. It is just a provision to send where to submit the application. Now, types of patent filing. Up till now we have seen what are the patents, what are the types of patents, how we can file the patent, which are patentable invention, which are non-patentable invention, what the forms are required, how much fees is required for that. Let us see types of filing of patent. There are 2 types of filing a patent. One is the provisional filing and second is the complete filing. Let us see. Provisional filing means just a filing patent with the abstract with form number 1, that is the provisional filing. And what is the complete filing? It is form number 1 to 980 with which detailed sketch and drawings. If you form file number 1 means provisional form, patent office just gives title to you for your patent, but it cannot be granted. But if you file a patent completely, then only patent office can consider your application for granting the patent, and that can be filed within 1 year after provisional filing. You go for provisional filing or not, you have to go for the complete filing within 1 year. Now, what is the process of grant? How grant process is done? First, upon publication, then writing of FER, patent office gives a letter to you. First examination report, we have to submit the satisfactory answer to the patent office within 1 year, that is the FER. If they are satisfied, they can grant the patent. So publication, writing, you are waiting for the FER, first examination report, filing response to the first examination report, and the decision of the examination decides whether it is patentable or not. Now let us see about the rights of patent. Patent rights are territorial rights. Means if you file a patent in India, then it is applicable, you can enjoy the rights within India only, not outside the India. So it is the in which country you have filed, you can enjoy the rights of the patent associated in that country only. But there is provision that no researcher can file a patent in 10, 20, 30 countries. But there is a provision of filing international application through single application, that is you can file by PCT patent cooperation technique. It is the Indian our system, international filing system, which can give benefit of your patent more than 150 countries. You can claim your patent, you can enjoy the rights more than 150 countries if you file your patent internationally through the India. But it is need that you have to take permission of Indian office. Then if you filed a patent in outside India without filing in India, then you can file the patent for India also within 1 year. Now, who can file the patent application? Who can file? Applicant himself, true, or the first investigator can file the patent. Secondly, jointly, patent application can be filed jointly with your research guide, research supervisor, or an institute. It can be filed on single name or can be filed jointly. Thirdly, you can assign the patent. You can submit your patent on your name, registered your patent by giving a letter to your assignee. He can go to the office and submit the patent of your patent on your name assignee through IPR authorized agent. There are the agents which are passed the Indian government examination of patent filing. They are licensed, and you can go to file the patent through the authorized IPR agent. They can charge any fees as per their decision. And these are the authorized IPR agents which are licensed by the government of India. Suppose I am not literate, I am illiterate person, and I have invented a thing. Then how can write that? How can file the patent? I am unknown. So at that time, I can take help of authorized IPR agent. They can help us by charging fees to file a patent on my name. I am illiterate. I am not knowing. So this topic of intellectual property is not related only to the teachers, not related only to the higher education institute, but it is related to all citizens of India, those who wish to file the patent. Unfortunately, after preparing the patent, if someone unable to file the patent, and if unfortunately if she or he is dead, then at that time the legal representative of that dead person can file the patent also. So what is the tenure of patent? Tenure of patent is 20 years. Not after that we can enjoy the rights. Copyright for 70 years. Designs can be enjoyed for 15 years. Plants builder right for 15 years. GI for 10 years and renewed again. At the same time, trademark is having life 10 years, but it is renewed every time, many times. Since we are finding that there are so many factories which are available in the market from last 200, 300 years, they are renewing that trademark because they are renewing their trademark. Let us see what can we do with the patent, with the or IPR. IPR can be assigned. Since intellectual property same treated as the physical property, means which laws, which rules are associated with our physical property, they are same associated with our intellectual property certificate. As we assign our physical property for financial benefit, then similarly patents can be assigned for the financial benefits. Patent can be sold as like our physical property. Patents can be gifted as like our physical property. So intellectual property is similar to the physical property. We can enjoy, we can treat them as a physical property. Let us see the infringement also. If someone is duplicating our product, someone is doing infringement is our product, someone is unauthorized using duplicating of the product, that time we can file a court case under infringement. So there is wrong to duplicate some product, to commercialize some duplicate product, because it causes the financial crisis or financial loss of that original company. On the screen you are seeing that okay, Ole, Colgate, Bisleri, Bilseri. So these are the product, different product. One is original, one is duplicate. So duplication should be avoided in that area. Let us see breaking news on IPR. Let us see IIT Madras faculty and researchers filed more than 184 patent in 2020 years. It's proud thing of us India that they have filed 184 patent in the pandemic days, and the total 9 patents were related to COVID invention. So need always is useful. Need always creates innovation and patent. What are the benefits from the IPR? what are the benefits? Protection of your innovation is the first benefit. Second, transformation of our basic knowledge into new product is the second benefit. And the author's institute gains reputation. Means if you have patents with you, then your reputation of institute in the society gets increased. And IPR attracts potential buyers. Means if you have patents with you, then anyone can able to approach you for invest. So IPR attract the potential buyers. And ranking improvement. If our institute is having more and more patent, then our ranking of that institute also increases. And lastly, I want to give a message to you that in the year of 1985, feel it, fit it, and forget it was the advertise of that Hero Honda bike, because there is tremendous change, innovative change in the available bike engines. Similarly, we have to think it for our innovations when we are publishing it, our papers, or any writing any doing any work, innovative work. We have tried to draft it, and we don't want to, don't forget it. Means which work we are using, doing in our daily life, if it is innovative one, you find the potential in that, and you go to filing, creating the IPR for yourself, for your institute. This is the message by me. Thank you to all for listening here to me, and thank you to organizing committee members, those who are invited me for presenting this speech. And if you have any questions in your mind, then you can go for asking to me. Thank you.
Thank you for sharing your experience, sir. I hope our students gain some additional knowledge about IPR. Thank you, sir. Students, do you have any questions, ma'am? Is there any doubts you can clarify with, sir? Sir Shri?
Okay.
Vote of thanks by B. Good afternoon, everyone. It has been such an honor to be a part of this wonderful event. On behalf of the organization, I would like to extend my heartfelt thanks to our chairman, Dr. K.R. Bhaskar sir, Vice Chairman Lata Bhaskar ma'am, Secretary Mr. K.B. Kishan Kumar sir, and Director of Institute of Management Mr. Shri Kishan Kumar ma'am. I wholeheartedly thank our Principal Dr. V. Vijayalashmi ma'am and Vice Principal Mrs. N. Maitri ma'am, and also HOD and faculties of Commerce Department. My special thanks to our Chief Guest Dr. M.M. BETKAR sir, Principal of Shri Kumarswami Mahavidyalaya, Ausa. My heartily thanks to students who are attending the program. Thank you all.
Thank you to all. Can I leave?
Yes, sir.
Thank you.
Thank you, sir.
Okay, ma'am. Okay.